This is Andre White, the plaintiff. He took a few steps into Hazen hallway and promptly slipped and fell on the floor, severely injuring his shoulder. He seeks an apology and compensatory damage for negligence. This is Victoria, the defendant. She promptly won the ownership of Hazen High School by defeating Nazi in rock, paper, scissors. She claims she holds no liability because her custodian staff took responsible steps for the safety of students. She seeks court costs.
Hello, I'm Doug. Yeah, I'm Doug Rogers. In a moment, we're going to hear a case of the Klutz and the spill. Here comes Judge Booty right now.
The situation you're about to see is real. The people are not actors. They are actual litigants in cases filed in a Washington municipal court. They have agreed to waive their right to trial and to have their disputes settled in our forum.
Please be seated. I've read your statements. I suggest that the crime was committed in the library with the candlestick by Mr. Green. Your Honor, it's the wrong case. Blasphemy, not again! Mr. White, you're a student at Hazen, correct?
Yes, Your Honor. I remember it was just yesterday. I was just walking down the hall, and then there was a giant puddle right in front of me. But it was too late. I slipped on it, and I fell on my back and injured my shoulder. According to tort law, I have the right to be free from bodily harm. I have concrete evidence that this right was not met because I brought you today a videotape from Mr. Bailey to verify my testimony.
Okay, let's see it. Thank you. Mrs. Scarlett, recall for me in your words the events of January 3rd.
My custodial staff takes top priority. I maintain the school grounds up to code. On Monday of January 3rd, like any other school day, sanitarian Mr. Chan mopped up the hallways after school, approximately 2:15, 10 minutes before the alleged accident. Anyways, during this time of year, the hallways get especially slippery because of the constant foot traffic tracking in water from the outside. I have a copy with me of Mr. Chan's contract, which includes the time of his scheduled cleanings, confirming my testimony of the floor being mopped nearly 10 minutes before it slipped. And I also have a written testament from my employee, Mr. Chan, stating that he mopped the hallways as routinely scheduled.
Thank you. Okay, cut. Alright, now that I've read the facts and heard the testimony from both parties, I'm ready with my decision. There's no legal requirement that property owners provide a constant remedy to the problem of water being tracked into a building, nor is there any obligation to continually mop a fall trapped in water. I find no liability because the defendant took reasonable steps for the safety of its students, so in view for the reasonable persons test, I find for the defendant, Miss Scarlett, and dismiss the negligence charge of $1,800. Case dismissed. All rise.
So, Judge Booty has fine with the defendant. Let's get a reaction. So, how do you feel about this?
I think kids should watch where they're going.
Okay, there you have it. Let's go get the plaintiff. The system is rigged. I freaking hate the system. Ah! My injured arm! Well, folks, that is all. This edition of the People's Court. Remember, if someone cheats you in life and you want to get even, don't take it in your own hands. Take them to court.